Assalamualaikum warahmatullahi wabarakatuh. Today we will discuss about false imprisonment. Yeah. Uh, Before this, we already discussed assault and battery. And for today again, we will discuss false imprisonment. So before that, we will look at what is the meaning of false imprisonment. Yeah. Okay, first, as you guys can see from the slide, false imprisonment is defined as the restriction of a person's freedom of movement without lawful justification. The person is imprisoned as he cannot move to another place in accordance with his wishes. Okay, and it covers any restraint on freedom of movement, even for a short time, and can take place outdoors as well as indoors. Okay, so from this definition, we can say that false imprisonment ni bermaksud it is some sort of infliction of uh, bodily restraint, yeah, bodily restraint, and that restraint is not expressly ataupun impliedly authorized by the law. Okay, so it is intentional. Intentional detainment or confinement of plaintiff by the defendant without any justification. Okay, so that's the meaning of false imprisonment. Okay, look at here. It is also defined as the infliction of bodily restraint which causes the confinement of the plaintiff within an area determined by the defendant, which is not expressly or impliedly authorized by law. The confinement can be accomplished using physical barriers, physical restraint, or threats, or threats of physical force. Yeah. For this, you guys can refer to the case of Collins and Wilcock. Di mana dalam case ni, if you read what the case said, the court defined false imprisonment as the unlawful imposition of restraint on another's freedom of movement. Yeah. So after we look at all this definition, we see that the meaning itself is very clear. Maksudnya false imprisonment ni, if someone asks you what is the meaning of your false imprisonment, you can say that it is basically restriction of someone's freedom of movement. Okay, and it must be unlawful. Alright. Contohnya, example, we have A, A got into fight with B. And then A locked B in a room without B's permission. So that can be considered also as a false imprisonment. And then the second example, A hold B hands in order to stop B from leaving, yeah, without B's permission. That can also be considered as false imprisonment. Or even A, katakan A, an employer, detains B to question him for unreasonable amount of time for katakan suspected theft, ya. Jadi itu pun kita boleh consider as some of the examples of false imprisonment, okay? The important thing that you need to know is that the restraint itself, it must be complete. Yeah, it must be complete. It must be a total restraint. Maksudnya, plaintiff cannot leave and there's no way for him to leave. Okay, because of some sort of physical barrier ataupun ada physical restraint ataupun ada threat of threat of physical force untuk mengelakkan daripada plaintiff pergi ke tempat lain, ya. So the defendant will be liable even if the plaintiff does not, dia tak tahu, even the plaintiff does not know that he is detained. Okay, it is sufficient that there is a total restraint. And another thing that you need to remember is that this is actionable per se, like what I've mentioned before. All trespass to person, all are considered as actionable per se. Yeah. So the plaintiff does not have to prove any actual injury ataupun damage. Sufficient if the plaintiff able to prove all the elements of false imprisonment. Okay. Alright, now after we've discussed the meaning of false imprisonment, let us look at what are the elements. Okay, the first one, we have the defendant must intended to restrict the plaintiff's freedom of movement. Okay, and then number two, we also have restraint. The restraint itself must be complete. And number three, the restraint itself is the what we call the direct consequence of the defendant's act. Yeah, but if you read other textbook, yeah, if you read the textbook by Norchaya Talib's, the textbook listed four elements, including the imprisonment must be an act, not omission. Yeah, but I believe you already know, yeah, because I already explained to you guys that the features of intentional thought, yeah, it must involve act, not omission. So we will focus on these three elements only. Okay. So the first one is the defendant must intended to restrict the plaintiff freedom of movement. This is element of intention. In other words, the defendant must have committed the action to restrain the plaintiffs intentionally. Okay. So katakan kalau if B, kalau katakan if A, we have A and B, ya. A katakan dia hold B's hand to stop B from leaving without B's permission. A must have the intention to do the act. A must have the intention to do that. If A, let's say A is forced by another party, then there is no forced imprisonment. Okay? So for this point, you guys can refer to the case of W. Elphinstone, this case, yeah, where the court in this case stated that the court held that the forced imprisonment cannot be established through negligence. Intention of the doer is a prerequisite. Okay? That's the first element. The second one is that the restraint must be complete. The restraint must be complete. It means that the plaintiff must be uh, restrained in every direction. Kalau kata ada, if there's a way for the plaintiff to escape, maksudnya there is no false imprisonment. But you need to remember that the means of escape itself, it must be reasonable. And it must not causing any risk of serious injury. Contohnya katakan A, we have A, ya. A katakan A is detained in a ship by B, you know. And maksudnya A tidak boleh larikan diri, there's no way to escape besides jumping into the sea. Okay? The only way to escape is by jumping into the sea. Okay? But unfortunately in this situation A could not swim. So then in this situation, we'll see that the means to escape is dangerous, yeah? We consider it as dangerous. So even if there is a way to escape by jumping from the ship, you know, into the sea, even though there's a way to escape, we consider that there is a false imprisonment. Why? Because the means ataupun the way to escape, the only way to escape is involving risk of serious injury to A who could not swim. So that's the example. Okay. You guys can refer to the case of Bird and Jones, where dalam case ini, if you baca the facts of this case, ya, di dalam case ini, the defendant put seats on the footway on the bridge, yeah, for the use of spectators, yeah, and the defendant charged, you know, for admission, yeah. But then the plaintiff refused to pay, and then the plaintiff insisted nak lalu juga laluan tersebut. So the defendant refused to allow him, and then told him to go back, you know, walk back, you know, along the carriageway to cross the bridge. But dalam kes ini, the plaintiff refused, and the plaintiff remained there for half an hour. So dia tunggu dekat situ, dia refuse untuk lalu. Okay, jadi after that, he brought the case against the defendant for false imprisonment. So dalam kes ini, the court, after looking at the evidence tendered by the parties, the court held that there was no false imprisonment. Why there was no false imprisonment? Because the court said that the restraint was not complete. Why the restraint was not complete? The restraint was not complete because the court said that the plaintiff can go back, and then he can walk along the carriageway, you know, to cross the bridge. Maksudnya dalam sini, there was a way to escape, and the way to escape was not dangerous. So the restraint itself was not complete, and because of that, the defendant was not liable for false imprisonment. Okay. The judge in this case stated that there was no imprisonment because imprisonment itself, it means dia kena ada total restraint of freedom, liberty. The plaintiff must not be able to move, okay, to walk, to escape. Yeah, look at what the judge said here. Yeah. The judge said that I cannot bring my mind to the conclusion that if a man merely obstructs the passage of another in a particular direction, whether by threat of personal violence or otherwise, leaving him at liberty to stay where he is or go in any other direction if he pleases, he can be said thereby to imprison him. Imprisonment is, as I apprehend, a total restraint of the liberty of the person for however short a time, and not a partial obstruction, of his will, yeah, whatever inconvenience it may bring on him. Okay, maksudnya there must be total restraint, walaupun singkat tapi dia mesti ada total restraint. Okay, alright. Similarly, you guys can refer also to the case of Wright and Wilson, where in this case, the restraint also was not complete. Okay, the restraint was not complete. Why? Because if you read the facts of this case, the plaintiff may go out by the door, ya, dekat, in the chamber. Okay, jadi dalam kes ini, there was no forced imprisonment. Kenapa? Again, because the restraint was not complete. Okay, so the principle is that jika ada what we call, if there's reasonable way out, we can say that there is no forced imprisonment. But when there is a reasonable way out, it must be used, dan plaintiff juga tak boleh claim that dia punya liberty, dia punya freedom of movement has been restrained. Sebab apa? Sebab forced imprisonment requires total restraint of liberty. So the restraint itself must be complete. Okay, so that's the second element. The third one, if you can see from the slide here, the restraint must be a direct consequence of the defendant's act. Okay, maksudnya the plaintiff, if the plaintiff brought the case to the court, the last element that he needs to prove is that the restraint is the direct consequence of the defendant's act, meaning the detainment, the restraining, the confinement is actually caused by the defendant, not by someone else. Okay, look at here. Let us read here. An action can only be brought against the person who directly causes the confinement. The person may be liable either because he himself confined or imprisoned the plaintiff, or that he instigated another person to confine or imprison the plaintiff. Okay. Example of the case, you guys can refer to the case of Hanat and Bond, where kalau you baca dalam facts of this case, ya. Dalam case ini basically, the plaintiff ni adalah mental patient, ya, mental patient dekat asylum, and that asylum was run by one doctor, ya. And the plaintiff later was given leave, ya, tapi with the condition that it is up to the doctor, whether if the doctor found out that his condition is not good, the doctor can call him back, to the asylum, yeah. Later, one doctor, the defendant, Dr. Bond, yeah, found out that the plaintiff was what we call acting strangely, because he's a mental patient, yeah. He was acting strangely, so the Dr. Bond detained the plaintiff for 3 hours. Okay, detained for 3 hours, and then after the detainment for 3 hours, then he was brought back to the asylum. Okay, so after that, the plaintiff brought an action against both doctors. First, the doctors who run the asylum, and another one is Dr. Bond, yeah. But in this case, the court stated that only Dr. Bond, who detained the plaintiff for 3 hours, was liable. Why? The court said that, and the court said that the another doctor, the doctor who ran the asylum, was acting under statutory duty. Okay, the doctor who because the doctor, the first doctor, they put him back in the asylum for his own good, yeah. And the court said that the wrongful one was the 3 hours confinement. So in this case, basically this case, the case of Hanat, it shows that the detaining of someone must be done by the plaintiff, by the defendant, sorry, by the defendant, and not others. So in this case, the 3 hours confinement was done by Dr. Bond. Yeah, the unlawful confinement was done by Dr. Bond. So in this case, Dr. Bond was liable, not the another doctor who run out the asylum. Yeah. So that's the facts of this case, the case of Hanat and Bond. So all of you can go back and find the facts of this case, yeah, the case of Hanat and Bond. So we can conclude that those are the 3 elements, okay, of false imprisonment. And we can say that the plaintiff needs to prove that, number 1, intention, meaning that the defendant has the intention to restrain his movement. Number 2, it's, the plaintiff needs to prove that the restraint itself, it must be complete. So there's no way for him to escape. Okay? And if there is a way to escape, the way ataupun the means of escaping itself is very dangerous. Alright? And number 3, the plaintiff needs to prove that the restraint itself must be caused by the defendant himself, not another person. Okay? So those are the elements that you need to prove. Alright. And then we will look at other things, other important things that you need to know. Number 1, you need to know that the knowledge of the plaintiff itself is not necessary. It is not essential. Okay, so this is the answer to the question of whether the plaintiff kena buktikan, plaintiff needs to know that he is actually being detained. Sama ada plaintiff, jika plaintiff nak bawa kes, adakah dia perlu buktikan pada mahkamah bahawa dia tahu bahawa dia adalah being detained. Okay, so as I mentioned here previously, the law is that the plaintiff, the plaintiff needs to know that he is being detained. Okay, this is the previous rule. Okay, meaning the knowledge of the plaintiff itself is essential. Okay, and then this whole principle, is being referred to in this case of Herring and Boyle. Kalau you baca dalam kes ini, if you read the facts, dalam kes ini, the schoolboy was actually being detained, but the schoolboy, that boy, he did not have any knowledge that he was in fact actually being detained. So dia tak tahu pun yang actually dia adalah sedang ditahan, ya, sedang di imprison, ya. So the court held that there was no false imprisonment because there was no knowledge on his part. Maksudnya he did not know that he was being detained by the defendant. So this is the previous rule regarding whether knowledge is necessary ataupun tidak. However, the position change. Okay, the current position change, where the current rule is that the plaintiff doesn't have to know that he is being detained. Dia tak perlu pun tahu sama ada oh, saya ditahan oleh seseorang. Okay, meaning the plaintiff, he can be imprisoned, he can be detained without him actually knowing that he is actually being detained. Okay, even if he doesn't know it, there is still false imprisonment. Maksudnya knowledge of the plaintiff itself is not necessary. Okay, it is not necessary. Contohnya katakan A adalah shop owner. Jadi satu hari A, suspek yang B ni mencuri sesuatu. Jadi A pergi kepada B, and then A goes to B, and then A asks B politely without saying anything. A told B, can you wait in this room, something like that. Okay, and then A closed the door. Okay, A closed the door and then lock B from outside, and then A stand outside the room, contohnya. And then dekat luar bilik tu, then A call the police. Okay, so B dalam bilik tu, B doesn't know about the fact that he is actually being detained in the room. Okay, selepas tu barulah it is proven, proven that B does not steal anything. Jadi jika kat sini kalau kata B brought the case, here we can say that there is false imprisonment even when B does not have the knowledge that he is being detained by A. Okay, what matters is that other elements are proven, ya. Maksudnya B ni perlu beritahu, perlu buktikan pada mahkamah yang A has the intention to restrain B, and then the restraint itself is complete. Maksudnya total restraint, ya. Maksudnya B ni dia tak dapat pergi mana-mana sebab pintu adalah terkunci dan A standing outside the room. Okay. And then number 3, B perlu buktikan pada mahkamah bahawa the restraint is caused by B. B is the one who did that thing and not because of another person. Okay. So that's the example. Contoh lain, all of you can refer to the case of Mearing and Graham White, where dalam kes ini, if you read the facts of this case, the defendant suspected the plaintiff of stealing, ya. Sama macam, lebih kurang sama dengan examples yang saya bagi tadi. So jadi dalam kes ini, the defendant, ya, asked the plaintiff untuk follow him to the company's office. Jadi the plaintiff entered the waiting room, and then in this case, bila kes ini dibawa kepada mahkamah, the defendant argued that the plaintiff was free to go where he wished. So that's the argument made by the defendant. So the defendant wants to say that there was no total restraint, ya. But the Court of Appeal dalam kes ini, this case went up to the Court of Appeal. The Court of Appeal held that the defendant was liable for false imprisonment. Why? Because the court said here that a person could be imprisoned without him knowing it. Jadi maksudnya dalam kes ini mahkamah mengatakan bahawa knowledge of the plaintiff itself, knowledge of him being detained is not essential, it's not necessary. Okay, jadi there is dalam kes ini there's false imprisonment. Okay, and the judge said that, look at here what the judge said. The judge said that it appears to me that a person could be imprisoned without his knowing it. I think a person can be imprisoned while he is asleep, while he is in a state of drunkenness, while he is unconscious, and while he is a lunatic. Of course, the damages might be diminished and would be affected by the question whether he was conscious of it or not. Okay. Maksudnya apa yang Lord Atkin cakap dalam statement ini, it doesn't matter whether that person knows about the fact that he is being imprisoned ataupun tidak. Satu, that person, the person who detained the plaintiff will still be liable. Okay, but what differentiate is that the amount of damages, that the court award to the plaintiff, it might be lesser compared to other facts, ya. Maksudnya maybe the plaintiff will only get nominal damages. Okay, and this fact supported in the case of Murray, yeah, this case, yeah, the case of Murray, where the court dalam case ini stated that a person who is unaware that he is being falsely imprisoned and then suffered no harm, the court said that he can only recover nominal damages. Yeah. You guys can read the case, the facts of this case, ya. Dalam case ini involving Murray, ya, this Murray, dia adalah suspek untuk yang untuk yang membantu IRA, ya. IRA ni adalah macam apa? Satu organisasi lah, ya, organisasi. Jadi the defendant dengan another soldiers, ya, arrested arrested Murray dekat rumah dia, ya. And the arrest was made under the statutory the statute, ya, the act. And then she was taken to the screening center and then she was interviewed and later she was released, yeah. So if you want to know more, please read the case of Murray. Okay, all right. And then another issue that you need to know is how about entering premises under a contract. Okay, so the rule is that, if you look at here, the rule is that if a person enters premises under a contract, he cannot sue for false imprisonment if he later wants to leave the premises in a manner or at a time outside the terms of the contract. Okay, Okay, if you don't understand, you refer to this case of Robinson. Okay, basically in this case, if you read the facts of this case, maksud dalam kes ini, the plaintiff dia nak buat a ferry, ya, dia nak buat a ferry, and the rule is that those who want to enter the pier, they need to pay a penny. Okay, those who want to enter, they need to pay a penny, and they need to pay another penny when they want to exit. Okay, that's the term. That's the term of the contract for those who want to board the ferry. Yeah, so the plaintiff paid a penny. They paid a penny semasa dia nak enter into the pier, but later he changed his mind. He changed his mind and he wanted to leave without paying another penny. Okay, so because of that refusal, the defendant refused untuk bagi dia keluar. Defendant kata you kena bayar dulu sebelum you keluar daripada sini, ya. So because of that, the plaintiff brought the case to the court. So jadi dalam kes ini mahkamah, after looking at the facts, after looking at the circumstances, the court said there was no false imprisonment. Sebab apa? Sebab the term itself, the term of the contract between them itself clearly stated that the plaintiff had to pay a penny when he entered and then had to pay another penny when he wants to exit, ya. Jadi tak ada false imprisonment dalam kes ini. Sebabnya plaintiff ni was doing something that was outside ataupun adalah bercanggah dengan terms of the contract, ya. Because the plaintiff refused untuk pay a penny when he wanted to exit the pier. Okay, so we can stop here. This is the end of our discussion on false imprisonment. We can conclude that you need to remember the three important elements. Okay, the first one, intention on the part of the defendant, and then the restraint itself must be complete. Okay, and number 4, the restraint itself must caused by the plaintiff, and you need to know that a knowledge of the plaintiff on his confinement or his detention, the knowledge itself is not necessary, it's not essential. Okay, the defendant can still be liable even though the plaintiff doesn't have the knowledge of the the imprisonment. Okay, and then a person who enter premises under a contract, he cannot sue for false imprisonment if he breach the terms of the contract itself. Okay, all right, so that's on false imprisonment. Thank you. Assalamualaikum warahmatullahi